Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. We have another busy docket again today, so let's get right to work. First, Harvey Weinstein, the sentencing explained. Second, an Evelyn Boswell update. Third, LETECIA STAUCH is in court today. Did I call it in my previous video? And fourth, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. We do appreciate you taking the time from your busy day to watch our little channel. First, if you're not already a subscriber, hit that subscribe button. Leave us a comment below on what we talk about today, and always hit that little bell so you receive notifications of when we put out new content. First, let's get right to work. Another busy day, a busy docket. First on the docket, the Harvey Weinstein sentence explained. Now, for those of you who do not know, Harvey Weinstein, former big movie mogul producer, let's just say not a good guy, had some 82 women who had made harassment or sexual assault complaints. 82 women had said that he had been inappropriate. This guy started and is the poster child for the Me Too movement, and he is now going to be in prison for 23 years. So a lot came out right before his sentencing. The court unsealed some documents that were filed by Harvey Weinstein's previous attorneys. And they had filed a motion, basically, it's a motion to quash the indictment. And they had attached some 1,000 emails showing that the complaining victims, witnesses in this particular case, had had an ongoing relationship, ongoing contact with Harvey Weinstein. And their argument was that a reasonable grand juror could not have indicted had the prosecutor made them aware of this ongoing relationship. That was never presented to the grand jury. Now remember, when you go to a grand jury, the prosecutor is the only one in the room, and they can be very selective. They simply have to present some evidence of each element of the charge to the grand jury. The grand jury signs it. Boom, rubber stamp. You've heard the phrase, you can indict a ham sandwich. Well, that's all it takes. Nobody else is in the room. I've personally been in grand juries where people are like, don't worry about it. Nothing's going to happen. And DA says, I don't think we have enough. So the grand jurors, do a no bill. It's very one-sided, and that's an understatement. Anyway, the court denied Harvey Weinstein's motion, but it was unsealed. Now, what's important in those emails are the fact that what Harvey Weinstein said. Now, he went to Jeff Bezos, Michael Bloomberg, Tim Cook of Apple, basically saying, hey, my world is crumbling here. My own movie studio, the board of directors wants to get rid of me. I need your help because we're buddies, we're pals. I've done good things, okay? This is what a lot of people like to refer to as the good guy defense. I've been such a good guy. Well, needless to say, none of these people came to Mr. Weinstein's aid or assistance. They let him go away. You do find out who your true friends are in any time somebody is in a criminal case of any nature. One thing is clear from these emails that have been released is that Harvey Weinstein's brother, Bob, the former co-chairman of the Weinstein Company, wrote, and I quote, "You deserve a Lifetime Achievement Award for the sheer savagery and immorality and inhumaneness for the acts you have perpetrated. Oh, I forgot. They were all consensual. Then what are you in rehab for? Sex addiction, period? Don't think so, period. You wouldn't have harassment, assault, and rape charges you now have received from 82 women for active consensual sex." So old Bob Weinstein is no fan. Although we had heard information regarding this falling out between Harvey Weinstein and his brother, this confirms it for sure. The sentencing today. Harvey Weinstein made a couple of big mistakes, okay? He went to trial. He's going to prison, okay? A lot of people seem to be shocked because he had to get 5 years. The judge gave him 23 when he was actually could get up to 29 years. I am particularly not shocked by the sentence at all, given the nature of the case. Harvey Weinstein got up there today and said he apologized and he had regrets, but at the same time, I was innocent, I didn't receive due process, etc. If he obviously the client has the right to say anything, but there is an appeal being made. The attorney should have said there's going to be an appeal. He's not going to say a word, and he's not saying only word on advice of counsel. All right. And frankly, I don't think Harvey Weinstein has much on appeal because the issues that the judge allowed in, which would be this 404B evidence of other crimes or misconduct, uncharged misconduct, the jury rejected that and found him not guilty of it. That was his best issue that he would have had he been convicted. But the fact that the evidence that was at issue, the jury sorted that out and said, no, we found you not guilty. So the chances of most cases on appeal is about 2%. So I don't think Harvey Weinstein is going to enjoy that. So he now has a 23-year sentence. A lot of people were shocked and said, oh my gosh, the average sentence for a case like this is 8 years. Well, this is not, one, an everyday case that you hear about. Second of all, the judge has to look at the statute as it relates to sentencing in the state of New York. The judge can impose any sentence within the range that is given. The sentence can be concurrent, so run together, or consecutive, which means you complete one sentence and then you will begin another, consecutive. But the court has to look at the sentencing factors, and although they're stated differently, whether it's in the federal system or the state system, and it varies by state, but generally these are what we refer to as sentencing factors. In the federal court system, they're referred to as the 3553A sentencing factors. And first, the court should impose a sentence sufficient but not greater than necessary to comply with the purpose of the sentencing factors. And the court then has to look at 1, the nature and circumstances of the offense and the history and characteristics of the defendant. So, for example, the reason why the defense attorneys for Harvey Weinstein brought up the fact that he had donated a bunch of money is they say, hey, look, he's a good person. He just made a mistake. And a lot of people make this huge mistake whenever they get in trouble is they say, okay, maybe I did this, but I'm a good guy. I should get a pass, okay? And the criminal justice system isn't about whether somebody's a good guy or a bad guy or he was a public figure or whatever. It's simply about, did the allegation that is alleged occur or not? That's it. It's not a defense whether you're a good guy. It's only a mitigating factor for the district attorney to consider or the judge at sentencing to consider when coming up with the appropriate sentence. And that's why they do a pre-sentence investigation report and they try to find out what somebody's background and characteristics are. Second, the need for the sentence to be imposed. Obviously, the greatest thing is to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense, right? Serious offense, serious punishment. Promote respect for the law. You can't have people running around violating the law. You can't have somebody out there not treating ladies with respect. And the punishment has to be just. Well, what's a just sentence? As long as it's within the sentencing range that the legislature has set out, it is a just sentence. You may not like it, but that's why judges have that discretion. Next factor is to afford adequate deterrence to criminal conduct. Now, that deterrence is not only for a defendant, but it's for everybody who knows about his conduct that has brought, for example, Mr. Weinstein here. Do you think Mr. Weinstein will be deterred? I would say probably yes. Because guess what? He's 67 years old now? He's got a 23-year sentence, and he's got charges going to be pending in California. He is adequately deterred. How about all those pigs out there who think, hey, it'd be cool if I can treat women inappropriately, hold the casting couch in my office or hotel suite, and think I get away from it because I'm a big, powerful guy? I think hopefully most of those gentlemen will think twice before engaging in such conduct. The next sentencing factor is to protect the public from further crime of the defendant. It's clear Mr. Weinstein has a problem. He's got some impulse control issues. Okay? Even if you're a sex addict, doesn't mean you go around raping people. Okay? And that's what he was convicted of. The judge ultimately has the duty to protect the public from future harm from the defendant. Does that take place for Mr. Weinstein? Well, given his age, given the fact that he will probably pass away in prison, whether it's in New York or California, I think the public is adequately deterred. And finally, to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. Basically, that provision is there is because most people that go to prison are going to get out. So if the person has a drug history, can we send him to or recommend a prison that has a drug treatment program? Will he be able to receive some sort of rehabilitation so that he is not just warehoused for a certain number of years and kicked out to the community? Obviously, Mr. Weinstein, if he does ever get out, well, he may not have many resources left to him in the end, but he'll be able to probably just live a quiet life if he ever gets out. Was a 23-year sentence particularly surprising to me in this particular case? No. I frankly thought that the judge would have given him the maximum sentence just for what this case stood for. This was the Me Too movement saying it has legs, gentlemen, and even if the ladies are out there that are sexually harassing men, I think the number is a lot less, but if you're doing it, you better stop. There will be consequences to this. So Harvey Weinstein may not have liked it. His attorneys didn't like it, think it was unfair. It's completely what I expected seeing cases like this in my own practice. So next on the docket, a quick Evelyn Boswell update. The only news that we have to report today is that the autopsy will remain sealed and not released to the public. Obviously, there's a great deal of interest in this. However, given the ongoing investigation, it seems unlikely that it will be released until charges are filed. Next on the docket, LETECIA STAUCH. She had a first appearance in court today. Just like I said it would take place, they received a copy of the complaint information. They waived any formal reading or advisement of the charges. There are 4 charges. We know one is first-degree murder. The remainder of the charges are more than likely tampering with evidence, tampering with abuse of a corpse, things of that nature. Once we get that actual complaint information, we will bring it to you for sure and fully explain the charges as well. Now, today at the first advisement, just like I told you, not a whole lot's going on. Little surprised that the defense waived the 35-day rule at this particular point, and that they asked for a status conference, which is now set for April 14th, to see what the status for the discovery is. As a defense attorney, I would have demanded that discovery be produced immediately, and then I will let the court know whether we'll be prepared to proceed within the 35 days. Now, the one public defender that Ms. Stauch had said that she had a homicide trial starting the week before or something along those lines in April. So she probably is like, hey, I don't have time for another homicide proof evidence presumption grade preliminary hearing. But I wouldn't have waived it until I got it. I would have forced the prosecution to turn that evidence over. They're the ones that charged it. They're the ones that arrested my client. I would have said, I want it tomorrow. Now, the judge was ordering that the district attorney produce to the defense attorneys the affidavit for arrest warrant so that they know what the heck the evidence is, because at this point, they don't have it, just like the public doesn't have it yet. The prosecution does not object to the unsealing of that affidavit, but the court was not willing to do so just yet. Additionally, we found out that there are some 107 search warrants that were issued in this particular case, not only in Colorado, but in South Carolina as well. South Carolina doesn't have a sealing provision, but all of the affidavits here are under seal, and the court will at some point authorize the unsealing of those search warrants so the defense can get a copy of them, even though they'll be produced in discovery. I'm a big fan of open records. I think that they should be made to the public. These are public documents. They should be available, and all the redaction stuff. We know who they're talking about. Who cares what their date of birth is? It's not that big a deal, but all the privacy issues these days, everything's redacted. It used to be you could walk in, pick up a court file, pull it, copy the whole thing, and walk out the door. It was good. One of the things that you'll note if you watch the hearing is that the defense attorney for Ms. Stauch was sitting in the jury box where they put the defendants while they're in custody because they don't have them sit at the table. She was blocking Ms. Stauch from the camera. Now, I guarantee you that was absolutely intentional. There's no doubt in my mind that the defense attorney sat there to protect her from the camera. At one point, she stood up. She couldn't do that, but that was absolutely done on purpose. Defense attorneys do that oftentimes so that, to protect your client from the media. Gannon Stauch's parents were in the courtroom. They're entitled to be at every proceeding. They will be flown back and forth from South Carolina for all court appearances at the district attorney's expense under the Victims' Rights Act. If there's a conviction, they'll ask for bill of costs that they'll never collect. They will be there at all court appearances. And you also saw that before they set the date, the district attorney went back and spoke to, again, Stauch's mother because they were clearing the date to make sure it was good for her. Because under the Victims' Rights Act, the victim in every case has a right to be present and to be notified of all court proceedings. And in a case of this nature, they're going to accommodate her being available. Ultimately, the judge said, hey, under the court rules here in Colorado, we have expanded media coverage only for initial advisements and sentencing. It's a silly rule. It should be available in the courtroom for any case. I don't care. It's just my personal opinion. But he basically told the media, don't file your request for expanded media coverage because it will be summarily denied because the rules just don't allow it. Basically, it's for arraignment and initial appearance, and that is it. So on April 14th, we will find out how much time the defense thinks they're going to need to go through the some 1,000 pages of discovery, and apparently there's lots of videos. But frankly, let's face it, 1,000 pages of discovery isn't that much. More than likely into discovery, there is a lot of duplicate information there because it seems like you always get 2 and 3 copies of the same thing, criminal histories, etc. So 1,000 pages really isn't that much, and most of it's not going to be relevant because it's probably tips and leads that the police had to go investigate. So I would have pressed on, but I get it. It's their case. Who knows what their client has told them. She may be in no hurry, but the bond will be addressed not at the next 21 days, but at the following court date after that, which will be the preliminary hearing and proof evident presumption. Great. And finally on the dock today, our dumb criminal contestant of the day. Now, oftentimes we have a dumb criminal contestant of the day where we actually get to see them in action. And here today we have Bryce Rhodes. Bryce Rhodes is showing us how stupid he can be. Now, I understand it. Mr. Rhodes is charged with 3 counts of murder, basically killing 2 individuals as it relates to killing them so that they didn't provide information on another homicide that he was allegedly involved with. And apparently he's been engaging in some pro se motions practice. And pro se means that you're proceeding without an attorney. But when you have an attorney and you file a motion with the court, it doesn't get ruled upon because you have an attorney. And so Mr. Rhodes had an opportunity to speak today, and you can see by the look on his attorney's face, who removes his glasses and basically puts his hands in his head, and he tries to tell Mr. Rhodes, basically, stop it.
Got some type of sexual relationship going on, or what y'all got going on, but I'm definitely going to speak my mind.
Detective Detelli and I have no sexual relationship.
Now I'm talking about you and the prosecutor over here, sir.
All right.
You denied all my motions. Every motion I filed, you didn't deny it.
I'm pretty sure I've denied the vast
Every
majority
motion I
of pro
filed.
se motions that have ever been
Are you some
filed.
type of racist? Are y'all got some type of sexual relationship going on? Which one is it?
Or are you just wrong in everything that you've made a motion for?
Are you a secret Ku Klux Klan member?
No, sir, I'm not.
Is that what you really are?
Nope,
Okay.
I'm not.
But he continues. He persists. And he persists in telling the judge, you must be having a sexual relationship with the prosecutor or you're a member of the KKK. Otherwise, you would be granting all of my legal motions. Or, as the judge seemed to indicate, maybe they're just wrong and there's no basis in law or in fact for any of his motions to be ruled on in his favor. So, Mr. Bryce Rhodes, yes, you are our Crime Talk Dumb Criminal of the Day. Congratulations. Thanks for watching. Have a great day.